So these are alternative dispute resolution mechanisms. So sometimes there are solutions to resolving what we call commercial disputes. So commercial disputes could actually maybe involve commercial transactions, for example, contracts. So companies have entered into contracts, but of course, there's a dispute that has actually arisen, so they have to resolve. So they can be able to resolve by simply opting for the alternative dispute resolution mechanisms. Instead of them having to go to the court, then they can be able to go for the alternative dispute resolution mechanisms. So there are several of them, but of course, these three are the major ones that we'll be able to look at, and of course, look at what are some of the characteristics of these particular three, and what are the advantages, and of course, some of the disadvantages of arbitration, mediation, and negotiation as an alternative way of having to resolve a dispute rather than having to go to the court. So they can be used to resolve some of the commercial disputes we can have involving commercial transactions, like, for example, business contracts, So what are the advantages of having to resolve commercial disputes? So resolving commercial disputes simply provides a remedy of an unwanted commercial situation. Then it enables you to present your side of the argument. It can be used to remedy an injustice done to you, maybe as a businessman. You can learn lessons about the way your business is actually run. Then appear strong, principled, and magnanimous. So it basically enables you to ensure that you stand with your principles. And of course, it is a better way of having to be able to resolve disputes. Then disadvantages, sometimes it is financially expensive to go for these options of resolving commercial disputes. Then it can lead to a lot of increase in stress and actually pressure. The senior executive's time is normally taken by being involved in the resolving of the dispute. So they'll have to appear, for example, before the tribunals, maybe for very long hours. Then it creates sometimes bad publicity. So you hear, for example, 𝒂𝒏𝒊𝒕𝒔 Breweries is under tribunal at KRA. It is actually basically at wrangles. It has a dispute concerning the tax liability they are supposed to pay to KRA. So they are before the KRA tribunal. So they want to resolve the matter before the KRA tribunal. So that tribunal basically now tries to resolve that matter between 𝒂𝒏𝒊𝒕𝒔 and of course KRA. So it is actually all over news. It creates a bad publicity about 𝒂𝒏𝒊𝒕𝒔 Breweries as a company. So it is always in the news about tax matters. So it can make some people not want to associate with the 𝒂𝒏𝒊𝒕𝒔 as a brand, because in this case, it simply means that they are not actually operating. So there's what we call business ethics. They're not actually operating ethically as per the expected ethics in terms of being able to run a business. They are not actually paying taxes. So there are those people, basically, if they hear such, they don't want to associate you with as a brand. It sometimes creates bad publicity. If each and every time you are resolving commercial disputes as a business or maybe as a commercial entity, it can create what we call bad publicity. Then it is, of course, expensive. It takes a lot of time for the chief executive officers. Each and every time they have to appear for media briefings, each and every time they have to appear before the tribunal. So instead of them having to focus on the business itself, creating strategies for the business, they are focusing on other matters concerning disputes. So basically makes them to waste a lot of time on other things that might not actually add any financial value to the business. So it wastes a lot of time. So the senior executive's time is actually normally taken. So we can start with arbitration. So as I've told you, arbitration, sometimes we call it being able to appear before what we call an arbitral tribunal. So these tribunals, sometimes they can be set up by a specific act of parliament or a statute law. Or alternatively, sometimes you've heard the president has set up a tribunal to resolve a particular matter or carry out certain investigations. So sometimes they can be set up by an act of parliament, a statute law, or for example, they can be set up by any party who has been authorized. For example, the president to be able to set up a tribunal to be able to carry out what we call investigations. So in this case, the affected parties will have to present evidence before the tribunal. So 𝒂𝒑𝒐 has to present evidence that that is not their tax liability before the tribunal. And 𝒂𝒑𝒐 has to present its evidence that that is basically is the true tax liability to be paid by 𝒂𝒑𝒐. Then the tribunal basically looks at this particular evidence, and at the end of it all, they'll be able to give a ruling. That ruling is the one we're actually calling. It is normally it is known as an award. So that ruling, basically declaration finally made by a tribunal, it is known as an award. So in the court we have a court ruling. So here it is actually known as an award. If you're not actually fully satisfied with what has been declared by a tribunal, then you can go to the next level. What is the next level? You can be able to go to the High Court. The High Court, as you're saying, under the structure, the tribunal simply under the court structure, if you can be able to remember it very well, under the court structure, the High Court is at the top, and of course now in this case it is like the tribunal reports to the High Court. So if you don't get a satisfactory declaration before a tribunal, where do you go to? You can be able to go to the High Court and simply claim that I didn't actually get a fair hearing. They didn't actually apply the principles of natural justice. The principles of natural justice. So the principles of natural justice in this case, we mean, for example, the right to be heard. You're not actually given the right to be heard, the right to be represented, the right to maybe present evidence. So there was actually what we call biasness. So they were biased towards 𝒂𝒑𝒐. They were biased towards 𝒂𝒑𝒑𝒐. And of course, if it is discovered that in this case, that tribunal is not actually applying the principles of natural justice or expected principles of natural justice as under the Constitution, in this case, it simply means that they can be able to make certain declarations whereby they can remove the proceedings from the tribunal to bring them before the High Court, or they can simply be able to give a prohibition order to stop the tribunal from having to continue with the hearings of that particular dispute. So this is an out-of-court method of settlement of civil disputes by arbitral tribunals, which make arbitral, can be able to see, it is not normally known as an arbitral award, as opposed to judgments. So judgments, our court rulings are basically the ones that actually happen in a court of law. So for them, they give what we call an arbitral award. They give what we call an arbitral award. So the law relating to arbitration in Kenya is contained in the Arbitration Act. Under the Act, an arbitration agreement is an agreement between parties to refer an arbitration all or certain disputes arising between them. Principles of natural justice in relation to arbitration proceedings are fundamental requirements of justice in deciding disputes between two or more parties. So principles of natural justice, the right to be heard, the right to present evidence, the right to be represented, the right for a fair hearing, the right for no any form of biasness, no any form of biasness. So those rights basically must actually be applied. So the principles of natural justice must actually be applied in having to resolve this particular dispute by an arbitration. So firstly, the arbitrator of the tribunal must be seen to be disinterested and unbiased. It is very important. You must basically, you as the arbitrator, so this particular arbitration body or tribunal, it is normally headed by arbitrators. So the ones who are going to resolve the matter. So if it is, for example, in this case, 𝒂𝒑𝒐, breweries, and 𝒂𝒑𝒐. So no way one of the parties sitting on that particular tribunal should have an interest, for example, in 𝒂𝒑𝒐, an interest in 𝒂𝒑𝒐, or any financial interest or any form of interest with the parties who are basically before the tribunal. Because in this case, if you have an interest, for example, if you are a shareholder at 𝒂𝒑𝒐, it simply means you'll be biased towards 𝒂𝒑𝒐. So there shouldn't be any form of bias. And if it is discovered, then you must not actually sit before that tribunal to resolve the dispute. So they have to look for other arbitrators to be able to resolve the matter. So the arbitrator or the tribunal on the tribunal must be seen to be disinterested and unbiased. So secondly, every party must be given a fair opportunity to present his case and to answer the case of his opponent. So he'll be given a right to be heard. So they have to come there as 𝒂𝒑𝒐 As 𝒂𝒏𝒊𝒕𝒂, you come there, also you present your evidence, they listen to you, they listen to this other party. Then, of course, they apply the principles of natural justice. And of course, they actually also apply what is actually provided for under the law. Under the law. Under the law. So we'll see later on that part of the disadvantages of being able to resolve a matter before a tribunal, sometimes they can misinterpret the law, because sometimes maybe they are not actually lawyers. So they're just experts who are sitting as arbitrators. So if they don't basically seek for advice from maybe lawyers or those who understand the law, they may misapply the law and, of course, resolve the dispute incorrectly. So those are some of the matters that can be able to lead to, if it is discovered they didn't actually apply the law appropriately, you have a right, as of course the affected party, to go now to the High Court. Then the High Court will be able to check, was there any form of misapplication or misinterpretation of the law in resolving this dispute by the tribunal. Then they can be able now to listen to the matter afresh. So that is part of the disadvantages or problems or shortcomings of having to go to a tribunal. So there could be biasness. So such kind of things can actually arise. Misapplication of the law, misinterpretation of the law. So such kind of things can actually arise. So what do? You go to the High Court. So the first principle is embodied in Section 13 of the Arbitration Act, which provides that when a person is approached for appointment as an arbitrator, he must disclose any circumstances likely to give rise to justifiable doubts as to his impartiality and independence. So that duty on the part of the arbitrator is a continuing duty right from the time that he is approached through to the time he accepts the appointment, conducts the reference, and renders his award. So what we mean by this, Kevin, in this case, if you are appointed as an arbitrator, you have to basically assess or basically declare that I don't have any form of interest in this particular dispute. So therefore, I can be able to serve as an arbitrator. So you have to basically declare once you actually approached to be an arbitrator or sit before the tribunal body. So the arbitrator must be on his guard with respect to connections with a party or connections in the subject matter of the dispute or connections in the nature of the dispute. And the test that the arbitrator must always bear in mind is whether a reasonable person not being a party to the dispute would think that the connection was close enough to cause the arbitrator to be biased. So you are not actually a shareholder at 𝒂𝒏𝒊𝒕𝒂. You're not a director at 𝒂𝒂𝒊𝒕𝒂. You're not a relative to a director at 𝒂𝒂𝒊𝒕𝒂. So there's no any form of connection. So you can actually basically be fair in giving the arbitral award or in having to listen to the dispute. So the dispute may be referred to arbitration by the parties to the agreement, by an act of parliament, a court of law with consent of the parties to the dispute. This is how now a matter can be referred to a tribunal, or basically an arbitration body. So the parties themselves, they can agree. As 𝒂𝒏𝒊𝒕𝒂 and 𝒂𝒂𝒊𝒕𝒂, you are not going to go to the High Court straight away. You can try to resolve our matter before the 𝒂𝒂𝒊𝒕𝒂 tribunal. The 𝒂𝒂𝒊𝒕𝒂 tribunal. So they go there, they try. If it doesn't work now, they go to the court. Alternatively, it could be an act of parliament. Maybe there's that act of parliament clearly states that you as an affected party, if you are a taxpayer and you have any dispute with 𝒂𝒂𝒊𝒕𝒂, to resolve the matter first before having to go to the court, you can be able to go to the 𝒂𝒂𝒊𝒕𝒂 tribunal to resolve the matter. Then if it doesn't work, is when now you can be able to go to the court. So a specific act of parliament can be able to give guidelines that any dispute arising out of any transaction of contract in nature to this particular act or statute law, then it can be referred to a certain tribunal body, So some of them are usually set up by acts of parliament. So remember, we said an act of parliament, it is a law that is actually made through parliament, sometimes known as a statute law. So there are several statute laws. So each and every time parliamentarians or members of parliament always come up with acts of parliament, So that is their role. That is what they do in parliament. So a court of law sometimes can be able to give directions that a matter be referred to a tribunal. So arbitrators may be appointed by the parties to the dispute. A third party has agreed to by the parties, the High Court on application, So the High Court can appoint one if the parties cannot agree as to who the single arbitrator shall be. In the case of two arbitrators, either party has failed to appoint an arbitrator within 30 days of receipt of the party's notice to do so. The two arbitrators fail to appoint a third arbitrator within 30 days of their appointment. So what are the powers of the arbitrator? To determine whether it has jurisdiction to hear the dispute. So they have to determine whether they have the powers. So they are actually mandated. That matter it is within their jurisdiction. It is within their mandate to be able to resolve it. If it is beyond their mandate, of course, they will say this is actually beyond our mandate as a tribunal. You cannot listen to this particular dispute. So maybe you can be able to go to a court of law, or maybe you can decide you just resolve it by yourself through negotiation. So it is not a matter that can be brought before this particular tribunal. So to provide interim relief or remedies where necessary. Interim relief is maybe solutions that can basically be agreed upon by the parties before they actually resolve the matter fully. So maybe they could agree that 𝒂𝒑𝒐 can actually open its operations for the next maybe 3 or 4 months as we basically sit down to resolve this particular matter. So that is an interim relief to the disputes. Because the problem now is the operations are shut down. So there are basically tankers of beer that are basically going to go to West. So instead of them having to go to West, they can basically agree for an interim relief. So maybe these tankers can be emptied. So this particular amount of alcohol can actually be sold completely as they actually try to resolve the dispute maybe within the next 6 months. So an interim relief can actually be given by the tribunal. And then to demand security from either party. So it is a high-profile dispute. It is a high-profile dispute involving a lot of money, billions of money. So even the arbitrators are actually fearing for their lives. They are fearing for their life. So maybe one of the parties is thinking that maybe these parties, the affected parties, would be thinking maybe he will rule against him. So he's actually basically fearing for his life. To determine the admissibility of evidence, to administer oath for all persons who come, for example, to give evidence, he has to administer oath that, of course, in this case, will be able to give truthful information. To examine persons on oath. So to examine the persons who can actually be able to give evidence, and of course, those persons who are actually before the tribunal for an oath. So the duties, so once the arbitrator is appointed, he must enter upon his duties without undue delay. And if the terms of appointment dictate, he must make an interim award. However, at the conclusion of the process, is bound to make a final award. So an interim is the one we are saying it is an interim relief, just to basically relieve the parties from maybe any kind of pressure or maybe stress. Then finally, once they have listened to the matter to finality, is when now he can be able to give a final award. Then the decision of the arbitrator is known as an award. It must be written, setting out the reasons for the decisions. It must be by majority and must be signed by all arbitrators. It must specify the date and the place at which it was actually made. So it is normally known as an arbitral award. So recourse to the High Court. So that is the recourse to the High Court. So the tribunal doesn't actually work for you. You can seek for a recourse to the High Court. You can go to the High Court, the higher level now. You go to the higher level now. So in this case, if the deputy doesn't actually basically resolve the matter, you don't just sit there. You go to the next office. You go to the next office. Maybe it can be able to assist you. It can be able to assist you. So what, of course, now in this case, if you go to the next office and it's the final office, so it simply means that maybe you can now maybe just wish for God to assist you because it is now the final office. So in this case, we are saying that under Section 35 of the Arbitration Act, the High Court has jurisdiction to set aside an arbitral award and by an application by either of the parties. To set aside has a jurisdiction or mandate. Jurisdiction simply means the mandate they have to set aside, to put it aside, to put aside an arbitral award if there is actually an application by either party. If, for example, in this case, 𝒂𝒑𝒐 applies, and for example, now in this case, if 𝒂𝒑𝒐 applies to the High Court, then of course they can be able to set it aside if the facts presented by the affected parties under the dispute carry some concrete evidence or carry some concrete weight. So So it simply means that now in this case, they can be able to set it aside and of course decide, we are going to listen to the matter afresh. We are going to listen to the dispute afresh and now give a court ruling. So the award will be set aside by the court if it is satisfied that, so these are part of the reasons as to why this award can be set aside. So one of the parties to the arbitration agreement had no capacity to enter into it. The arbitration agreement was invalid in law. The party was not offered sufficient notice for the appointment of an arbitral tribunal. The arbitral tribunal was not constituted in accordance with the terms of the agreement. The award relates to a dispute not contemplated by the agreement. Then the award is contrary to public policy of Kenya. The dispute is incapable of resolution by an arbitration. So those reasons can be able to lead to the High Court having to set aside an arbitral award. So once the award is set aside, the parties are free to file the dispute in a court of law. So arbitral proceeding may be terminated in the following ways. So the making of the final award, withdrawal of the complaint, mutual consent of the parties. So what are the advantages of having to resolve a matter before an arbitration body? It is cheap. It is relatively cheap compared to having to go to a court of law. There's a lot of speed, so they can decide they're going to sit on a daily basis. But instead of having to go to a court, they'll tell you, come after 3 weeks, come next month. So for them, they can set aside the whole of this week. They're going to sit on the matter and resolve it. So it is faster method of dispute resolution in that the diaries of the arbitrators are generally accommodating. They are very accommodating. Convenience, the arbitral proceedings are conducted at the convenience of the parties in terms of venue, time, the law, and language applicable. Informality, arbitral tribunals are generally free from technicalities which characterize ordinary courts. So sometimes you've heard a matter has been taken before a court of law, but it has basically been thrown out of the court due to technical issues. Maybe they presented evidence late. They presented evidence not in the correct format. So such kind of technicalities basically simply lead to a matter having to be thrown away by the courts. You have to, for example, now file afresh. But of course, there are time limits. So if you fail to meet the time limits, then that will be the end of it all. So the presidential election petition must actually be filed within how many days? So if you fail to file within those particular specific days, then it will be thrown away due to technicalities. You presented evidence quite late. And of course, maybe you presented the evidence not in the prescribed formats. So on technical grounds, they throw it away. They throw it out of the courts. And then expertise, knowledge, and specialization. You can be able to seek for expertise and knowledge and experts to come and actually sit before the tribunal. You know, in a court of law, this is a person who has studied all along law, matters to do with law. He's a judge. But of course, now in this case, if it is a matter to do with finance, it is a matter to do with maybe science, you can basically look for one of the arbitrators to be a scientist and come and actually sit before the body. You can be able to explain most of the matters. Maybe you can just have one person having to be the one who has basically studied law. And of course, these other persons are actually expertise. So they have specialized, they have knowledge in matters to do with tax. So they have studied CPA up to final level. They know matters to do with tax. They have practiced, for example, now in this case, as maybe auditors or basically tax advisors to several clients. So they can be able to come in and of course give their expertise and actually knowledge. But of course, for a lawyer, all the time is actually in court of law. For example, now in this case, if he has to resolve that matter, he has to do a lot of research, a lot of consulting before he can be able to now give the final judgment or actually ruling. But here you can be able to seek for expertise because there could be maybe 3 arbitrators. One of them is a tax advisor who has practiced for the last 16 years. So the other one basically is a lawyer, so the best lawyer in the world. So the other one basically is actually also maybe an advocate of the High Court. So they can be able to understand the matter very fast. So there's a lot of expertise, knowledge, and specialization. Parties are free to refer their dispute to the most specialized arbitrators in that particular field. So you can choose the best arbitrators in the whole of the country. So you bring them to resolve the matter. So privacy and confidentiality. Arbitral proceedings are conducted privately, free from public scrutiny. So the parties enjoy the requisite confidentiality. Flexible. So arbitral tribunals are not bound by previous decisions. So these affords them the necessary room to explore. You know, for example, courts, we said they apply what we call judicial precedents, or what we call case laws. So these judges of the courts, normally they normally apply what we call judicial precedents. They'll be able to make rulings by simply having to refer to rulings that were actually made in the past. So the 𝒉𝐼 ruling, the 𝒉𝐼 ruling. So people are even still referring to it right now, even if there is a presidential election petition in the year 2022 before the Supreme Court. In the 𝒉𝐼 ruling, so you can be able to hear the judges mentioning, in the 𝒉𝐼 ruling, the votes at the polling station are actually final. So he's making a reference to that to be able to basically build on the ruling that he's actually making at that particular time. So he's making a reference to what was basically ruled in the past. So they actually basically sometimes tied. That's what they are saying here. So arbitral tribunals are not bound by previous decisions. So it allows these particular arbitrators to be able to explore. It's not a must that they make a reference to previous rulings or decisions. They can be able to do a fresh investigation, a fresh compilation of evidence, and come up with their own unique arbitral award. But for courts of law, they always sometimes make a reference to previous rulings that were actually made in the past. That in the previous ruling made by Justice Maraga, it was actually a requirement that IEBC, before it basically conducts an election, it must have met these particular requirements, that all the results must have been transmitted to the portal. Were they transmitted to the portal? You can be able to see they are making reference to previous decisions, But here, it simply means that you carry out fresh investigations, fresh evidence, and you can be able to make your own unique ruling without having to base it on previous decisions made by other tribunals. It tunes down acrimony. Arbitral proceedings are less acrimonious, and parties generally leave the proceedings closer than they would have been in the case of a court of law. So in the court of law, you stand there, so the other parties stand there. So there's a lot of some form of acrimony can be able to be seen by the parties. So what are the disadvantages? Likelihood of miscarriage of justice. Arbitral proceedings may at times not guarantee justice, particularly if the question is actually complex and the arbitrator is not well versed in law. That's what you are saying. Sometimes there's usually the disadvantage of misapplication or misinterpretation of the law. So you can be able to make an arbitral award that is not actually basically conforming to the provisions provided by the supreme law, which is actually the Constitution. If that particular award is against or goes against the Constitution or any other relevant law, for example, a statute law, it simply means that in this case, there has been the misapplication of law or misinterpretation of the law by the arbitrator because he doesn't understand matters to do with the law. He's not actually well versed with the law. That's what you're saying. If there are three arbitrators, maybe you can be able to get one expertise and of course also get one of them who understands matters to do with the law. He's actually a lawyer or maybe an advocate. You do a lot of interpretations of the law as you basically approach the matter before the tribunal or before the arbitrators. Arbitral awards have no precedential value. They cannot be relied upon in other disputes. So it is advantageous to some extent and also disadvantageous to some extent. So it matters as to how you argue your case. So they cannot be relied upon anymore in the future. So arbitral tribunals exercise unregulated discretion. So sometimes to regulate them, it is not easy. So not each and every time the High Court will be there to supervise them. The High Court will have to sit there listening to them, what they do each and every day. So there's that particular problem as to how they can be regulated. Because some of these arbitrators, sometimes they can act beyond their powers or set limits. So not each and every time the High Court is there to watch and supervise them, check on what they are doing. Very difficult to be able to supervise them. So they have what we call unregulated discretion. Unless maybe if it is, maybe there's actually a complaint before the High Court, that's when the High Court can be able to discover or actually realize. So that is what we mean by arbitration. That is what we mean by arbitration as a way of having to resolve a dispute, So we can start on mediation, but maybe we can take a break of 1 or 2 minutes. Then we can continue with mediation. So we can look at mediation. So mediation, it is an informal and confidential way for people to resolve disputes with the help of a neutral mediator who is trained to help people discuss their differences. The mediator does not decide who is right or wrong or issue a decision. Instead, the mediator helps the parties to work out their own solutions to their problems. So this is not like under arbitration, whereby the arbitrator gives an arbitral award. So the arbitrator gives the solution. Here, the parties themselves who are actually under the disputes are the ones who will be able to resolve the matter on their own. They'll craft ways as to how they resolve their own disputes. So this mediator simply creates an environment whereby he's able to bring the party under the dispute together. They can be able to sit together. So this person is known as a mediator. So an example we've used is, for example, the post-election violence in 2007. There was a famous mediator, the late Kofi Annan. So he was actually able to create an environment for the parties under dispute to sit together and craft their own solutions. So the coalition agreement. So what are the benefits? So it is less costly. So while a mediator may charge a fee comparable to that of an attorney, the mediation process generally takes much less time than moving a case through a standard legal channel. Confidentiality. So while the court hearings are public, mediation remains strictly confidential. Control. So mediation increases the control the parties have over the resolution. In a court case, the parties obtain a resolution, but control resides with the judge or the jury. So the parties can be able to take control of the matter because they are the ones who are crafting the solution. So they can be able to take control of the matter. So compliance. So there is high levels of compliance under mediation. So like, for example, that one under the post-election violence, the parties were actually able to comply like to 100%, So because the result is attained by the parties working together and is mutually agreeable, compliance with the mediated agreement is usually of high levels. This further reduces costs because the parties do not have to employ an attorney to force compliance with the agreement. Then mutuality. Parties to a mediation are typically ready to work mutually towards a solution. In most circumstances, the mere fact that the parties are willing to mediate means that they are ready to move their position, Then support. Mediators are trained in working with different situations. So the mediator acts as a neutral facilitator and guides the parties through the process, So the qualities, so just almost similar to the advantages. It is a voluntary process. It is collaborative. It is controlled. The parties take control of it. It is a confidential process. Informed. The mediation process offers a full opportunity to obtain and incorporate legal and other expert information and advice. So you can always be able to maybe seek for expertise or experience from persons who actually understand the matter before the mediator. You can seek for expertise from experts. So impartial, neutral, balanced, and safe. The mediator has an equal and balanced responsibility to assist each mediating party and cannot favor the interests of any one party over the other. Because the mediator does not have any interest. He's not the one who's basically resolving the matter. He just creates an environment and can only just be able to advise. It's for the parties themselves to craft a solution for the problem that is before them. Self-responsible and satisfying. Based upon having actively participated in voluntary resolving issues, participants' satisfaction and the likelihood of compliance are found to be elevated through mediation compared to court options. So that is what we mean by mediation, and those are some of the advantages and qualities or characteristics of mediation. Negotiation. So it has been defined as any form of direct or indirect communication whereby parties who have opposing interests discuss the form of any joint action which they might take to manage and ultimately resolve their own dispute between themselves. Negotiations may be used to resolve an already existing problem or to lay the groundwork for a future relationship between two or more parties. So this is basically can be applied, for example, in resolving family issues or family disputes. You just sit together and decide to negotiate and actually agree. Instead of having to run to the court, a lot of courts that will be incurred, why don't you just sit down as a family and negotiate and resolve the matter to completion? You'll waste a lot of time having to go to the court. You'll waste a lot of resources. Why don't you just sit down? So you are members of the same family. You can be able to resolve your own matters. You can be able to negotiate and actually just resolve and just resolve instead of having to go to a court of law. So negotiation has also been characterized as the preeminent mode of dispute resolution, which is hardly surprising given its presence in virtually all aspects of everyday life, whether the individual or institutional, national or global levels. Each negotiation is unique, differing from one another in terms of subject matter, the number of participants, and process used. So in our daily life, we basically apply this one. We apply this one. We apply this one. So you, for example, if it is maybe at work, there's a duty roster, you're not actually able to agree to it. So I and Kevin, we are the ones under the duty roster. You can be able to negotiate and say Kevin can be able to report at maybe from 8 to 1. Then I report from this time to this time. Maybe over the weekend, I have a gig, I have a party I want to attend. I've been put on the duty roster on Saturday from maybe 2 p.m. to 6 p.m. So that is the prime time. That is the prime time of the party. That is the prime time of the party. So you just basically agree to negotiate with Agade, and of course agree that Agade can report that time, and of course you report, and you can negotiate. So it is applied in our everyday life at institutional levels, at national levels, and even at global levels. So given the presence of negotiation in daily life, it is not surprising to find that negotiation can also be applied within the context of other dispute resolution processes such as mediation and litigation settlement conferences. What are the characteristics? It is a voluntary process. You cannot basically be coerced or be forced to enter into negotiations. You can just decide you are going to refuse to it. You don't want to meet this person and agree to negotiate. So no party is normally forced to participate in negotiation. The parties are free to accept or simply reject the outcome of negotiations and can withdraw at any point during the process. You can basically refuse to come for that afternoon shift. You can just refuse to come for the afternoon shift and of course just say, I report for the shift which have been put on the rota. I cannot make way for this other party. So maybe there is actually enmity between the parties. So it is a voluntary process. Bilateral and multilateral. So negotiations can involve 2, 3, or dozens of parties. They can range from 2 individuals seeking to agree on the sale of a house to negotiations involving diplomats from dozens of states or countries. For example, the WTO. Non-adjudicative negotiation involves only the parties. The outcome of negotiation is reached by the parties together without recourse to a third party, for example, under mediation and arbitration. It is informal. There are no prescribed rules or procedures as to how you can be able to craft negotiation processes. You can just meet informally, even in a restaurant, and simply negotiate. You can just maybe sit for like 3 minutes and simply negotiate and agree on a matter. So the parties are free to adapt whatever rules they choose, if any. If any, is not a must they be there. It is confidential. So that dispute between the husband and the wife, it is quite confidential. You cannot be able to tell. But of course, they can be able to sit together over the night and of course just negotiate and actually agree to resolve the dispute amongst themselves, the husband and the wife. It is very confidential, very private. People might not actually even be knowing what is happening, but you are of course actually able to resolve your own matters or disputes. So when you walk out here, you're just holding each other's hands. So they say you are actually a perfect couple, yet there are disputes. but of course you work towards the dispute. So like that, it is very confidential. Flexible. So the scope of negotiation depends on the choice of the parties. So the parties can determine not only the topic or topics that will be the subject of the negotiations, but parties also whether they will adopt a positional-based bargaining approach or an interest-based approach. So positional-based approach is, for example, in this case, you just take the position and you stick with it. Interest-based is whereby you try to accommodate the other party. As you basically contribute to the points, you actually also allow the other party to contribute and try to get some sense in his contributions so that you can be able to come up with a concrete decision. But a positional one is whereby you just take a position. This one is mostly actually normally adapted by a person who thinks that is actually very superior. It is actually your employer and you are the employee. You are trying to negotiate over maybe the salary. So he takes a particular position and just sticks with it. It doesn't like actually try to accommodate your contributions or maybe your views. Because it's the most superior, the most powerful one, then of course he can be able to just maybe sway you to go with that particular position. That particular position. So what are the advantages? In procedural terms, negotiation is probably most flexible form of dispute resolution as it involves only those parties with an interest in the matter and their representatives, if any. Like any method of dispute resolution, negotiation cannot guarantee that a party will be successful, that a party to a dispute will actually be successful. However, many commentators feel that negotiations have a greater possibility of successful outcome when the parties adapt an interest, when they adapt this particular one, but we are saying you accommodate each other person's views, as opposed to a positional one, whereby you just take your position. So the other party might feel that you think me, I'm very inferior. You think if I leave this particular employment, I won't get another job. So continue being with your position. Let me just leave and seek for another job. I'll be able to get it even within the next 3 days or 4 days. Within this month, I'll have another job. So I can just walk away. Why do you take a positional-based approach against me in terms of negotiating for the salary? So I won't stay here. So such a case, it simply means that you as the employer and the employer, you've not resolved the dispute. But of course, if he basically takes an interest-based approach whereby he's actually able to listen to you as the employee, then you can be able to agree on something. And of course, you can continue to stay as the employee. Negotiation is voluntary. It is a voluntary process. There is no any form of coercion. You can decide I'm going to negotiate or I'm not going to negotiate. I'll just resign. So I don't have to negotiate over these kind of things. So I just have to resign. So there is no need for a recourse to a third party or a neutral party. Unlike the outcomes of certain adjudicative processes, the courts, the outcome of a negotiation only binds those parties who are involved in the negotiation. The agreement must not, of course, be contrary to the law. It must not actually be contrary to the law. Then, assuming that the parties are negotiating in good faith, negotiation will provide the parties with the opportunity to design an agreement which reflects their interests. Then negotiations may preserve, and in some cases even enhance, the relationship between the parties once an agreement has been reached between them. Then opting for negotiation instead of litigation may be less expensive for the parties and may reduce a lot of delays. Disadvantages. So a particular negotiation may have a successful outcome. However, parties may be of unequal power and the weaker parties may be placed at a disadvantage. So where a party with an interest in the matter in dispute is excluded or inadequately represented in the negotiations, the agreement's value is normally diminished. So whereby for example, now in this case, the one who's actually very powerful takes a positional-based approach, then it doesn't basically satisfy both parties. So a successful negotiation requires each party to have a clear understanding of its negotiating mandate. If uncertainty exists regarding the limits of the party's negotiating authority, the party will not be able to participate effectively. You must actually be able to understand the matter at hand so that you can be able to negotiate appropriately. So what are we negotiating over? What are the facts? You need to have all the facts so that you can be able to bargain for yourself. You can be able to negotiate for yourself. So the absence of a neutral third party can result in parties being unable to reach an agreement, as they may be incapable of defining the issues at stake, let alone making any progress towards the solution. The absence of a neutral third party may encourage one party to attempt to take an advantage over the other, the employer over the employee. No party can be compelled to continue negotiating. Anyone who chooses to terminate the negotiations may do so at any time. So that is basically also a disadvantage. So anyone can just simply be able to walk out against you. So you are negotiating, you are basically at a restaurant, you are negotiating, then the party just walks away. You are left there wondering, what am I going to do now? So this person has walked away. So no one can be able to compel him to come back because it is a voluntary process. It is a voluntary process. So some issues or questions are simply not amenable to negotiation. There will be virtually no chance of an agreement where the parties are divided by opposing ideologies or beliefs. You can't change their beliefs. So you can't change their beliefs. So where Agande comes from, they have their own beliefs about men. Where Kevin comes from, they have their own beliefs about women or ladies. So they have already taken a belief. They have already basically taken a position. So trying to change their mind, it is not actually very easy. It is not actually very easy. They have their own ideologies and actually beliefs, which leave no room for mutual concessions. So they can't even concede. They can't even give room for you, for yours, your beliefs. So you can't change them at all. The negotiation process cannot guarantee the good faith or trustworthiness of any of the parties. So you might agree today, but tomorrow the opposite is actually happening. You had agreed that you as parties under the negotiation will not actually do this and this, or will have to fulfill this. Tomorrow you come, the opposite is actually happening. So you have to start negotiation again afresh. So, but you know, if it is actually a court of law, they'll give a court order. They'd give a court order. So that court order will simply be able to prohibit you, because if you go against it, then you'll be penalized or you can be fined. So there'll be penalties or fines. But here, there are no kind of penalties or fines. You can agree today, tomorrow the opposite is happening. You have to start afresh again, the negotiation process. It may be used as a stalling tactic to prevent another party from asserting their rights. Someone can be able to use it as a delay tactic. So a delay tactic. So today you find him, he has committed the mistake, you negotiate, you agree, you continue staying together. Tomorrow again, like that. So he's just delaying, maybe targeting something. Then you'll discover when it is actually very too late. It was just a delay tactic. It was just a delay tactic. Maybe there was something he was actually basically benefiting from him, or she was benefiting from him. So it's just using the negotiation process as a delay tactic. So you'll discover quite very late. It was a delay tactic. Litigation could have even worked better. Arbitration could have even worked better instead of having to go for the negotiation process. So, so what are the negotiating styles? So position of best, I've tried to explain it. Interest-based approach. So there are usually two. Interest-based is whereby you try to accommodate the interests of the other parties. Position of best, you take a position and you stand with it. You don't basically sway or go left, right, and center. That is the position, and we have to agree to it. It is sometimes very disadvantageous. It sometimes makes parties not to be able to reach an agreement. It is called a position of best approach. So there are other methods of resolving disputes. So for example, you can have an ombudsman. So an ombudsman is a person who investigates complaints and attempts to assist the disputants to reach an decision. So we've looked at arbitration, mediation, and negotiation as the major ones. But of course, we have others. You can have an ombudsman. So they are saying in this case, a person is actually appointed to investigate complaints and attempt to be able to give a decision or resolution. So usually this is an independent officer of the government or a public or quasi-public body. An ombudsman can be classified as an alternative dispute resolution mechanism. So early neutral evaluation. So this is where parties to dispute consult a third party with regard to the dispute. The third party can then advises them on the likely outcome of the conflict should it actually basically be referred to a court of law. So you basically seek for expertise advice. So they can be able to advise you. If you go to a court of law, this is likely to be the ruling. So maybe it is better you just negotiate and resolve it very fast instead of having to go to a court of law. Then mini trial. So this can either be judicial or private, and it is similar to ENE, or early neutral evaluation as above. In judicial mini trials, the parties are already in the court and they go before a judge. The synopsis of their cases are presented and the judge advises on the likely outcome if the matter was actually taken to trial. So private mini trials mostly occur in large organizations where members or senior managers of an enterprise receive a summary of the dispute and essentially suggest ways of resolving them. Expert determination. It is where the parties to the dispute appoint a third party who makes a binding decision upon hearing the parties. He must be an expert and makes his decision based on such expertise. His decision is normally binding. Adjudication. It is where an adjudicator is appointed to settle disputes. He is appointed as a neutral third party, entrusted to take initiative in ascertaining the facts and the law relating to the subject matter in question. Then we have the customary ways, African customary ways, traditional ways. You can be taken to elders. So each community has its own Njorinjeke of their, for example, of their Meru, 𝒂𝒏𝒐𝒕𝒉𝒆𝒓 of the Kisi, 𝒂𝒏𝒊𝒕𝒚 of the Kikuyu Luo Council of Elders. So there's normally what we call the Council of Elders. So you can be taken to elders. Sometimes you've heard in the community that someone has committed a wrong. So they say we have to call elders to resolve this one. So it is also a way of resolving disputes in the communities, so traditional ways. So they are recognized by the Kenyan courts just as African customary law. So the 𝒂𝒏𝑆𝒓 draft, or basically the 𝒂𝒏𝑆𝒓 draft that was used to basically write our constitution, also basically recognized this one as a source of law. So resolving disputes under the African customs way, way. So these are ways of how you can be able to resolve disputes alternatively instead of having to go to a court of law. So that is what we mean by alternative dispute resolution mechanism. So that is the end of this particular topic. So unless there's actually a question, you can be able to ask at this particular point. But I've done a lot of talking, so maybe now I can be able to open the forum for you guys to be able to maybe ask any question in this regard. So I don't know if you people have been able to book your exam. Have you been able to book your exam, or you haven't booked? Because now this is actually the second sitting for this, but I think it's the second one for CFFE. So I don't know if you've been able to book for the exam. Have you been able to book for the exam? It is the second sitting for CFFE. So I can see Agade says not booked yet. Deadline is on 4th of November. But you've been able to confirm the subjects you're undertaking. Because if you've done CPA, there are form of exemptions. If you've done a degree, there are form of, I think, some exemptions. So you need to confirm the exemptions quite early enough. So I don't know if you've been able to log into your portal. So there's normally a portal that you are given. So I don't know if they give portals for CFFE, but you can be able to confirm with CAST and this quite early. So what you can do, if you are in Nairobi, you can just visit them. or you can be able to give a call. But sometimes I'm normally told when you make a call, I think their customer care is a bit poor in terms of calls. So maybe if you visit physically, then you get the concrete information as to which subjects you are going to be exempted. So once you've been able to confirm that, then yes, 2 papers for part 1. I visited the office. So which ones are you going to be exempted? Agade, which ones are you going to be exempted? So let me see if I can be able to get the syllabus here. If I can be able to get the syllabus here. Yes, 2 papers for part 1. I visited the office. I'm exempted the audit paper. I am a CPA, the audit paper. Or this one, Introduction to Forensic Accounting and Audit. So it simply means you'll have to do fraud and corruption schemes and overview of the legal and justice system. I don't know what about the others. Kevin, are you in the same situation? Mola, are you in the same situation? So Mola, I can see also Mola exempted audits. So Mola is actually sure. What about Kevin? The same situation. So I think the subjects you'll undertake is fraud and corruption schemes and overview of the legal and justice system. So that is, I think, quite okay. I think we're actually on track. We're actually on track because
I think
yes,
if you have a degree,
yes,
the CPA surpasses the degree, so you have to be exempted. Even if you have the degree and the CPA, they base their exemption on the CPA. But if you have a degree alone, then they look at the degree only. But if you are a degree and you are CPA, they look at the CPA.
Or they don't consider the degree.
Yeah, they don't consider, because the first question they ask, have you done a course, our course? Have you done a 𝒂𝒆𝒏 course? Yeah.
Okay.
So I don't know about the degree, guys, but if you have a CPA, you exempted the audit paper.
Audit paper.
Degree waliniambia the only degree where you are exempted different unit is a low degree peke yake. The others, the same boat as we.
Unless you have CPA.
Yeah. But only a low degree alone. The exempt you. I think there are some things. So one for module 1 and one for module 2.
Or module 2.
Yeah.
Okay. I get the point. So that's okay. So I think we are on the right track, because like in this particular paper, we are not far away from having to cover the syllabus. So I think we are within the correct time limit.
Mwalimu, let me ask something.
Yes.
Something very serious. I can see we are almost done with the syllabus.
Yes. So what will remain?
Swali 100 zitatoka kwa hii syllabus. I don't know. It's crazy.
What we'll do?
Sasa hapo ndio mwalimu atatusaidia kurevise sasa hiyo story.
We'll revise after we've done with the syllabus. We'll go. We'll go and actually check at the app, because they have actually tested once. That is the only past paper you'll come across. So what we'll do,
hata sijui zinapatikana wapi. Mimi nimezitafuta hata ninunue. Acha hata kupewa. Mimi nilikuwa natafuta zangu nipae. Hakuna.
You can't get them. So maybe you can be able to use that one as a model to see the approach of how they test. Then now maybe you can formulate some questions, look at them deeply as we compare with that one. That because it is the only past paper that is there, because it was the first time they tested it in the last setting.
Yeah, alafu
yes.
Si utume kwa group ile link ya zile vitabu wanakuanga ameweka kwa ile library yao, zile vitabu kubwa hizo.
I think I'll look for them. I try to check for them, and then online, then I can be able to also share.
Because mimi najua naweza zi access. Niko na subscription kwa online libraries ile zenye ziko na unlimited books. So yeah.
Okay. So I think I'll be able to check on that. If I can be able to share also the links for further materials for reading, the better. You can even do your own research at your free time about a particular issue, so like that. So I think that is what we'll do Agade.
Pass mark ni ngapi?
You're saying?
Pass mark ni ngapi?
I saw the
50
question.
plus 1.
I can't even understand.
50
50
plus 1.
plus 1.
The normal pass mark, I think it's normally
50%.
50%.
Kasi kunanga kuhurumiwa ni 50.
50%.
In
100 questions, you get 50 of them.
50 of
That
them.
is like less than 2 minutes per question. Hakuna kufikiria ni kutik tu.
Mimi hata na prefer hii kuliko ingine ya kuandika booklet mzima. Easy printing, you know why I'm saying that? I have done exam with exam bodies that require you to type using a computer. Sasa wacha hii ya kufinya ABCD, the typing itself. Mungepata hiyo mungeti. That one is hard. You have to have the typing speed. Na sasa sisi computers kutuliana tu tukapewa certificate ingine tu ya vitu. So this one for ABCD is at least. If you get the one which you are told now the exam is computer based, but now you have to type. Like when unafanyanga kwa CPA. Uko question tu unaangalia unaona ni 2 hours. Una speed.
Mimi tu sina shida na hiyo, but ile kizungu imetumika hapa.
Sasa hiyo I think from the experience tuko nao ya 𝐒𝐿𝐶𝐵 ni nini? Ni watu tu wanapenda mtu asome extensively. Na research extensively. Because with 𝐒𝐿𝐶𝐵 ukilala kidogo unauma nje. Those guys are not friendly at all.
No, we are just with 1 month.
You will make it. You'll make it. You'll make it. You don't have to worry. Agade.
Watu wangapi walipita hii mtihani last time? Mko na statistics?
I haven't even.
Dr. Ura alikuwa anasema
said everybody.
Of all people he taught, all of them passed.
Yeah.
That's why usually says that CFFE is easy, but I doubt. Hakuna kitu ya 𝐒𝐿𝐶𝐵 rahisi. Never ever.
Because me, I'm looking at this paper. There is a problem.
Aki. Answer zinaenda kufanana. Alafu nimeona ingine iko na answer paka ya all of the above. Na hiyo
ndio answer. Surely. I'm a true or false.
So you need to like comprehend the answers very properly.
Sasa hii ni ya kuunderstand. Hii si kama AFR ya kushika formula tu. Kijua formula una flow.
You have to comprehend the content very properly.
Yeah. I think it looks easy, lakini si rahisi venye inakaa.
Si rahisi. It's not easy. It's like what you normally do, like an aptitude test. So you do so many questions very fast. So you are not actually keen with the answers you are giving.
Yeah.
You'll end up having to score even almost a 0. So I think we'll look at the questions after we've done with the I think by next week we'll almost be through. Then next month we can focus on how we can be able to approach the exam like that.
Okay.
Like that. I think that will be okay.
Sawa.
Yeah, hiyo ni strategy mzuri. At least we have that month. Cheza na hizo maswali.
Cheza na hizo maswali.
Paka ziingie kwa akili.
So you guys can have a good evening. Let's meet. I think we'll meet.
Na by the way, the Friday class ilihamishwa lini? Kwa sasa zingine unajipatanga umeacha shughuli za Friday.
Because on Friday there's actually a clash. There's another class I have.
And what about we decide right now tuipeleke Saturday?
I think Saturday.
Saturday kwani uko na nini?
You are where are you on Saturday?
Nini jioni?
I'm working.
You're working on Saturday.
The whole day.
Almost.
Okay. Nini na Sunday?
Sunday wewe watu waende church wapumzike.
Okay. On Monday you have
tuko karibu kumaliza syllabus bwana.
On Monday let me see on Monday what
lazima tutafutie mahali itaingia. Hiyo hatuna option.
Let me check on
Even
Monday.
Monday is okay.
Monday
basi tunaweza kuwa na 2.
Monday you have from
Monday me I'm doing the nini analytics.
Sasa na unaona
you have the analytics.
Yeah, on it, catching up.
Oh, you're doing data analytics also?
Yeah, but for the exam, just to.
Ya kujinini,
personal studies.
Ya kujikumbusha. Okay.
Okay. On Monday, but on Monday I can see from 8 p.m. you have fraud and schemes. So what time do you normally do that data analytics? Because data analytics is from 8.
Yeah, data is from 8. But no, when they clash, you just look at data and you see, okay, fine, nini gani, unarudi kwa hii CFF.
I was thinking we do it on Monday from 6.
Monday 6, I think is okay.
Okay. It's okay.
Monday 6, then on Wednesday again on 6 at 6.
Yeah.
Okay.
Yeah, that's
yeah, iko sawa. Sasa at least najua Monday 6
p.m. and Wednesday 6 p.m.
Yes, that's okay.
Sawa. Thank you.
Sawa.